Justice Kagan?
Harris, I think I'd like to know more about how controlled substances are identified. I mean, the Controlled Substances Act is obviously not written with 922G3 in mind, right? It's like the separate statute, which presumably has its own purposes and methods and so forth. And I mean, one of the things that might be considered in determining whether something is a controlled drug is a person dangerous when that person is on the drug. But I guess I would be surprised if that was remotely the primary thing. So could you just tell me about like the whole range of things that are considered in deciding whether something ends up as a controlled substance?
Yes, and it's in 21 USC 811C as sort of the list of criteria. And while they don't specifically list dangerousness, I'll get to why I think they're a good proxy. It lists things such as the potential for abuse and addiction, the state of the science, the pharmacological properties, the history and pattern of abuse, its scope and significance, public health risks, whether the drug is a precursor for other illegal drugs. And in the course of the determinations, as I mentioned, these are not just subject to judicial review through the APA process and also subject to rescheduling challenges. But in the course of the process, it's obviously a dialogue among agencies with respect to does consider such things as DEA's views, which again tends to consider connections to public safety and crime. So again, the intuition that what they're focused on is what are the effects, what are sort of the mind-altering effects of this particular drug and how dangerous is it when you're on it, is a fairly tight fit for such other categories, including the mentally ill, which this court has said is presumptively legal. I think it would be hard to say, no, you can't, it's not enough to say there's this kind of risk of abuse, this kind of public safety concern in general, and say Congress isn't doing a good enough job because it's not specifically considering exactly how dangerous is this particular drug when mixed with firearms. The point is it's dangerous at any level when it's being used in an illegal way.
Okay, so a different question. In thinking about these analogs and what counts and what doesn't, do you recognize a difference between statutes that go to public safety, like we're really afraid that this person is going to commit crimes against other people, and statutes that go to what we might call public order? So there's a person who keeps on falling down dead drunk in the town square, and we want to remove that person from our environment, that sort of thing. It seems to me that those are two different kinds of concerns, which might end up in the same statute or might not. And how do we think about that in terms of the analogs that you're pointing us to?
I think that's a valid concern. I think it's one that Blackstone's recognized with respect to surety laws, and I think the court should be attentive to it. But the answer here is, I think the overlapping nature of the historical restrictions and what they sound in. So the civil commitment laws, I think, are the easiest example I'd give you. They're focused on habitual drunkards. I think it's very clear to say that the reason is, as Blackstone sort of would have put it, the fear that people are going to be out and about sort of terrorizing the public or doing other unsafe things, similar to the mentally ill. And the vagrancy laws, I will obviously spot you that there is a wider range of concerns within them, but I think you can piece apart the different purposes, both with respect to some of the manner of handling them and just historically how those laws were understood with respect to specific categories of people. And then three, I would say the post-ratification history can help you distinguish between, is this public order, we don't like this kind of person being around for aesthetic reasons or whatever it is, or public safety, we think there's a real danger for having this kind of person on the streets or at liberty without restrictions. And I think the post-ratification history here, and again, the fact that habitual drunkards laws translate very closely into the illegal drug user laws as soon as that problem emerges in the early 20th century, late 19th century, is another way of telling you this is how you do the calculus. And I don't think it can be throw all the laws out the window or you have a problem with surety laws in Rahimi, because they covered all sorts of stuff.
Thank you.